Hello and welcome back. I'm Nettie Owens. This is what businesses need to know right now. You can actually check out the entire series at whatbusinessesneedtoknow.com. Today, I've brought with me Radiance Harris. I'm so excited to bring her to you so you can learn a little bit more about IP law, which may be something that you've explored before and had some questions on. So let me tell you a little bit about Radiance. She's an award-winning trademark attorney, best-selling author and speaker, and as the founding and managing attorney of Radiance IP Law, she helps emerging businesses nationwide protect, monetize, and grow profitable brands with trademarks. She has successfully represented startups and multinational corporations across diverse industries. Previously, she worked at one of the world's largest law firms representing Fortune 200 brands. So welcome, Radiance. I'm so glad to have you here.
Well, thank you. I'm excited to be here.
Well, let's jump in and see what we've got. So tell me, you specifically focus on trademark law. What is the difference? Because there are so many different terms out there between trademark, copyright, patent, and trade secret. And we've heard them all bantered around. So
yeah, great question. Yeah, so they all fall under the umbrella of intellectual property. Most people refer to that as IP. So with trademarks, that protects elements of your brand. So when you think of your brand, you think of your business name. Maybe it's your doing business as name. Maybe it's a product or service name, logo, tagline. Those are all things that can be protected by trademarks. Then copyright protects your content. So all of the content that you are flooding out into the world. So like this video is protected by copyright. Blogs that you write, training manuals that you create, anything, photographs. So any content would be protected by copyright. Then you have trade secrets, which protects anything that's meant to be kept a secret. So a special business process, a formula, recipe, any of those things would be protected as a trade secret. And then lastly, patents protect inventions.
That was so clear and simple. And I definitely have heard them kind of misused, just sort of blanket. Right. But that was really simple. So I have just a curiosity as you're saying this. For any of these, is there anything you have to do to protect yourself? Is it automatically protected, or do you have to take steps to make sure that once you put these things out into the world, they're registered or protected in any particular way?
So a lot of business owners mistakenly believe that they automatically own their business name just because they filed for an LLC or a corporation with the state, or because they got the domain names, the social media handles, and that's a misconception. The reality is that a U.S. federal trademark registration is necessary to establish exclusive legal rights and protection in the names that you're actually doing business as. So it would be important to secure trademarks from the U.S. Patent and Trademark Office to actually legally establish ownership in the names that you're building your business on. As for copyright, that actually sticks automatically. It sticks automatically, but there are benefits to securing a copyright registration from the U.S. Copyright Office. Especially when it comes to having to enforce those rights. A registration is necessary. It's a prerequisite to any litigation or enforcement matters. Patents, you can only secure a patent from the U.S. Patent Office, so that's a formal. And then trade secrets are actually protected through contracts. So you protect your trade secrets by, one, keeping it a secret, so only sharing with people on a need-to-know basis, and those who you are sharing with, making sure you have the right contracts in place. To make sure that it's not leaked out and remains confidential.
Wow, that, again, super, super helpful. I know these are things that a lot of business owners are like very laissez-faire about. They think I think they fall to that category of, I think it's just done and taken care of, or I'll get around to it one day. And so they're not really paying enough attention to it. So let's go back to that first one, trademark. And what can you trademark? You mentioned a few different things. Logos, names, maybe dig a little bit deeper into that.
Sure. So yeah, trademarks can protect anything that's meant to serve as a source identifier. And what I mean by that is that when your prospective clients and customers see your name out there, or see a course name out there that you're doing, or a podcast name out there, you want them to automatically associate that with you. You don't want to associate it with your competitors.
Right.
So what a trademark does is it gives you the exclusive legal right to use that name in your industry. And so you want to protect things such as your business name, your doing business as name, the name of your podcast, the name of your blog, the name of an event you're doing. Maybe you're doing an annual conference or event. That's something that you would want to protect with trademarks. There's a tagline that you're using. There's a logo that you're using. That's another thing. If you're writing a book series, that's something else that you would want to trademark as well to ensure that you have protected. And I actually did it for my book series, Trademark Like a Boss, and also Copyright Like a Boss is another series that I have that I'm working on. But you would want to protect those things to make sure that when people see that name, see that brand, they think of you and not your competitors.
Excellent. All right. So when is the best time then to start this process? It seems like you would have to have created it, right? Ahead of time, but is this a chicken and egg kind of thing? When do you start the trademark process?
Well, ideally, you actually want to start it before you adopt a name. So before you actually start using, because you actually can start the trademark process before you even start using a name. It's called an intent to use trademark application. So ideally, the best time is to do it before you adopt it, to make sure that you do your research and do your trademark search and make sure there's no issues or conflicts that you would run into before you start the trademark process. So I would say that's the most important time to do it. The reality is business owners don't do it until after the fact. They want to see if the concept works, or they want to see if they make money, and then they want to go and protect their IP. So other times, in addition to before you actually adopt use of a name or logo, you definitely need to protect your trademarks before you license. You can't license anything that you don't own. So if you're like a course creator or having some kind of mastermind program where you're sharing content, you want to make sure that you have IP ownership before licensing. Also for any brand extension. So maybe you started doing one-on-one services and now you want to expand it into doing something else. That's another time where you'd want to make sure that the trademark that you want to expand into this new territory is actually available for you and not infringing. Also, if you want to expand geographically, let's say you're a local business and now you want more of a nationwide presence, or maybe you want more of an international presence. That's another time when you would want to consider the trademark process. And then lastly, definitely before you start hiring anyone. So if you start out as a solopreneur and then now you're hiring independent contractors or employees, anyone in your business, that's a time where you want to protect yourself, because you don't want to be able to allow for the opportunity for anyone who's working from you to claim intellectual property rights in the content that you've created.
Yeah, that's definitely a sticky situation if you haven't done anything ahead of time. Quick last question, and that is just on the line of, we always talk about what do businesses need to know right now in the marketplace right now? What are you seeing around trademark law? What do you think business owners are missing? What do they need to know?
Well, I will say this, that there have been record-breaking numbers for trademark filings with the U.S. Patent and Trademark Office. So 2020 was a record-breaking year. So what's important about that is that people are starting to recognize the importance and value of trademarks. They're investing in their trademarks. It shows that, economic trends are going up. So that's a good thing. So I think because trademarks have become more, I guess you can come in the popular culture. Now you can read a news article or watch Entertainment Tonight and they're talking about trademark disputes or trademark issues. So I think now it's become more of like a buzzword. People are now kind of recognizing it. But the reality is that all businesses have trademarks, but there's only value if they're protected.
Oh my gosh. I was imagining, there's actually been a reduction in the population in 2020, fewer people having children. I think we put all of our energy into creating new ideas.
Yeah, because you realize you can't put all your eggs in one basket. A lot of people lost their jobs. So they're like, let me get this other business. Let me get this side hustle started.
Absolutely. Oh my gosh, this has been fascinating. Thank you so much. Radiance has some great resources at her website, radianceiplaw.com. Please go check it out. And if you have enjoyed this presentation, please leave a comment ask a question. Let us know, what did you get? What did you learn? Did you have an aha moment while we were discussing IP law, everything you knew, or something that was new to you? Thank you so much, Radiance, for joining me today. It's been a pleasure to have you.
My pleasure. Thank you again.